you all Okay, thank you all very much for your cooperation, your patience. If you'll please be quiet. When the jury comes in, please, if you have your cell phone on, please turn it off. So I appreciate your cooperation.
We haven't come back in. I think Mr. Glenn's on.
Okay, I'll go off the record. I'm sorry, I didn't realize he wasn't here. Record that all counsel present, Mr. Tisdale is present, the jury's outside of the courtroom. Magdal, are you ready to have him come in?
Yes, sir.
The defense ready to have him come in?
Yes, sir.
Okay, let's see. Thank you all very much for bearing with us. We appreciate your patience with us. We'll give you back all your attention.
Ladies and gentlemen, on behalf of myself, Mr. Eisenhower, Bruce Colton, your state attorney, and the people of the state of Florida, I want to thank you. Now, I know we said thanks the first day you came over. We say thanks every morning, and it kind of gets somewhat, I imagine, sounding insincere. Excuse me. But here's the deal. We know what this entails for you. As I'd indicated in jury selection, I would imagine that some of the things that have transpired during the course of this trial are things you would normally go home and talk to your loved ones about, or your coworkers. And of course you couldn't work, and you couldn't talk to your loved ones. And it's difficult. This is a major inconvenience. But I'll go back to what we talked about that very first day. I hope you now have an appreciation for an incredible system. A system where you step in between your government and one of your fellow citizens to mediate a dispute. Only in America. Now, you know, I got ahead of myself in my last closing. I missed a slide. And my slide was going to be, what's the defense? Because it's an indefensible case. Now I've heard it. Luckily I guessed it a little bit. And we're going to go through that one step at a time, but I want to take up one issue first. Mr. Glenn said to you, quote, if it was premeditated, why didn't he kill those two dudes? I think is the quote. Meaning Jerry Pilarski and Albert Krajniak. And this is all in the context of, I basically accusing the members of the law enforcement agency that testified before you of lying. Fair enough. All's fair in a criminal courtroom. But make no mistake about this. Jerry and Albert, who witnessed this event, perhaps because, as Mr. Glenn says, imagine this. Clarence showed up. Clarence Bennett showed up. And so maybe, instead of a liar, maybe he's a hero. It stinks. Ladies and gentlemen of the jury, it's about reasonable doubt. I talked to you about this in my first thing I said to you. And here's what Mr. Glenn didn't talk to you about, reasonable doubt. It's not a, see if any of these words sound familiar. Possible, speculative, imaginary, or forced doubt. Does it sound like, imagine this, or I have a theory, or I don't know what the truth is, but do those sound like speculative things? Look, all I can do is show you the facts. Your job is to draw conclusions on that based upon what you've observed. Because, as we indicated earlier, I don't know what runs through people's minds. But I certainly know what one's common sense might suggest based upon facts and not my imagination or ruminations or speculation. So, let's look. Here is the defense. This is it. This is all they got. It was sudden and spontaneous. Now, you will not get an instruction from the judge about sudden and spontaneous. There's no legal defense called sudden and spontaneous. I guess what they're saying is it's sudden and spontaneous, so he didn't premeditate. Fair enough. We're going to talk about every bit of that. But there ain't no such thing. And guess what else you won't hear? You're not going to get self-defense instruction, justifiable use of deadly force. You're not going to get excessive use of force by the deputy. So you're left to imagine or speculate about this sudden and spontaneous act. So, I agree with the defense. The dispatch tape tells it all. Now you're going to get that dispatch tape, and here's how it's going to work. You're going to have a laptop. It's clean, so you can't go on the internet, because remember, you're not supposed to do anything outside this courtroom, and you can play that disc. And when you play that disc, if anybody's got any computer aptitude, there'll be a little counter, and it'll start at 000, and it'll run to the end, which 5 minutes and some odd seconds. Obviously, the pertinent part is the front end of it. Watch the counter, do your own math. Let's do a little state math. So, what does the dispatch tape tell us? It tells us that it wasn't a spontaneous and sudden event. 000 to 0033 is the initial call out. 1050, 166. It's hard to hear. Dispatcher says, he says then something about 23. You know, I think that's wrong. It might be 3200 block of mirror. You listen to it. That's my dyslexia at work. And then she says where, basically, King Orange. Now remember, here's the deal. What did Wentz tell you? Wentz told you what we do is we try to determine, we try to figure out where we're going to be, and we're calling ahead. That's why this original call out, whatever it is, 3200, 2300 block, ends up being incorrect because he didn't feel like stopping at that when Gary thought he would stop. So they continued down the road. When he's calling out at 33 seconds, our place is going to be King Orange and Mira. They're not there yet. Now, let's talk about Casey Fedniak just for a moment, and I'm moving on. Because what she tells you is, down, King Orange, take a right. She loses sight of the defendant's car. Now, does the defendant's car stop somewhere on the side of King Orange? It seems like probably because Gary stops, right? Rolls, slows down, makes sure he's not going to run into anybody, rolls through the stop sign, stops. Casey says it seemed like 5 seconds, okay? Let's say it's 10 seconds, right? Now, how much time do we have before 33 seconds and that, all right? Now, I'm not asking you to speculate, but what I'm saying is time is ticking at that point. But what she says unequivocally and clearly, and she can see, is Gary never gets out of the car. So why do they keep saying that? How can you say something that has no basis in fact or reality? That's not the evidence. That's not the fact. The fact is, he never left. And what she says is the car, she looks down, takes off, the car is gone. Now she says 5 seconds. First of all, when people estimate time, it's a totally a crapshoot. But she did say another interesting thing to you. She said, and then about 45 seconds later, I heard the gunshots. It's almost dead on. So she's a pretty good estimator of time. But what's more significant is he never got out of the car. And I don't know why we're talking about it. Because it's irrelevant. It means nothing. So let's keep going. So here's that time frame. This is the nefarious part of the case, where something bad's happening. We don't know what, but let's all assume that the cops got to be up to no good, because that's the jaded society we live in. 34 to 57, SOE's taken off. And then this. 58 to 106, right? So it's from this point in time, SOE's taking off. They're asking for a direction. He said, we're north on Naylor. The last words ever spoken by Sergeant Gary Morales. And you know what's deafening? The silence between 107 and Clarence's call out, shots fired. That silence is deafening, because in that period of time, Sergeant Morales is losing his life. Now, the time, right? Because they made a big deal of the time. He gave you some suggestions of what the time is. But what we know is Clarence Bennett says, SO, we got shots fired, and we know that that'll happen at, again, that counter will now be at 1 minute and 57 seconds. 1 minute and 57 seconds. What did Clarence tell you? Clarence told you this. He said, I called out after the car was leaving. I said, about how long did all that take? There's no way to know. All he can do is estimate, and he told you about 30 seconds. So let's do this. Let's start here. Let's go to here. 1 minute and 57 seconds. Let's subtract 30 seconds, and that gives us 1 minute and 27 seconds. You see that clock? Right here? Watch this clock. And start now. So we got shots fired. That's 1 minute and 27 seconds. Now listen, he did not have to form premeditated intent the second he jumped out of his car. For 1 minute and 27 seconds, he is engaged with Sergeant Morales. He is aware of Sergeant Morales' impression. He is thinking, what am I going to do? This is not the car stops, he jumps out, and then he decides to shoot. This is a long time. That's a long time to think, to reflect, and to act. Now, here's the issue. That's giving him, as he is absolutely entitled to, every benefit of the doubt. But that's from the moment Gary Morales keys his mic. That's assuming, listen to me, that's assuming that that is the very instant in time that the defendant becomes aware Gary Morales is behind him. Because that's when lights are on and we're coming down Cantor going to Muir. But what about this? What was the defendant doing Again, we don't know because he murdered the person who could tell us. But what was he doing that day? What Jessica Maldonado said is he went to the store to get, what was it, ice cream? Or excuse me, orange juice?
Judge, I'm gonna have to your motion.
All throughout the course of this trial, it's your job to recall the facts and evidence. But Jessica Maldonado indicated the defendant went to the store. So I ask you, if that's where he was going this day, if when he left the house with his suspended license and his firearm, he was going to the store, there's nothing in the car that suggests he made it to the store or got anything at the store. And then Mr. Glenn did this with you. And I didn't know how quite to do this because this requires some speculation. But what we do know is I guess the store is up here somewhere, the 7-Eleven, or she may have said a Cumberland Farms or something, a little, I don't remember, a little store or something like that. Anyways, this is how he'd have to come home, right? One of a couple ways. Down Orlander, onto Canner. Now this is what Mr. Glenn said during his close. This is what he, he's saying, well, how, this is how it happened, and then where does he see Gary, and then down Mura to where he would live, right? That's how he'd have to come home. The problem with that is that's not the fact. Now that's where he'd be coming from if he was at the store. But we don't know that he went to the store. We don't know that he ever went to the store. And if he went to the store, in order for Casey Fed, there's no impeachment of Casey Fedniak that when she said, what? Lights and sirens, I see him turning off Canner coming from the east. Left onto Mura. Now, think about this. If you're up at the Cumberland Farms or up at the store, are you going to go, what, north on Oleander to, what is it, Edwards east all the way to US 1, US 1 all the way down to Glenview, Glenview south on 7th, and then west on Canner? But my point to you is, what was he doing over here when Gary came upon him? And so when we use here's my point, I don't know, but my point to you is, the timeline I gave you is only when he clicks up the mic. 1 minute, 27 seconds. And during that time, the defendant has a cop behind him, and he's got a gun in his car, and he's got a suspended. Is that enough time for premeditation? If it isn't, then I know your verdict. And then she says, south on Mura. So, was it a sudden and spontaneous act? Well, the defendant ran from Morales. Why do people run? Again, that is. He's right. Mr. Glenn knows me well. He knows I'm an argued consciousness of guilt. Guilty people run. That gives you insight into his mind. He literally could have pulled over to the front of his door, except that he really couldn't. Because if he had pulled over to the front of his door, in the security and the safety of his own driveway, where bad things couldn't happen to him, bad things that we wish to imagine, I guess, but he couldn't because he would have been arrested. And then here's Mr. Glenn said over and over, how much sense? It would be stupid for him to murder Sergeant Morales knowing that there's this, what's it called, Darryl? This high intensity, whatever, the extra patrol. He didn't know. He didn't know. Guess what? The sheriff's office doesn't make a point of broadcasting the fact that they're going to go into a neighborhood and work it. He had no idea. It just so happens he picked a bad day to be out driving with a suspended license and a firearm as a convicted felon, because there was that patrol. And that cost Gary his life. But he had no idea. You don't give him any credit for that. Where and how does the only record evidence indicate the defendant kept his firearm? There's only one witness in the record that testified about that firearm and where it would have been prior to this incident, or where she had seen it. And again, to be fair, she said a couple of times, but it would have had to have been where, I mean, the record evidence is there. And in the car, in the glove box, we've got our holster. Okay, so let's see. How does this work against a, quote, sudden and spontaneous act? Again, she told you you kept it in the glove box and it was unloaded. Now, does that mean that there was no round in the chamber? I don't know. That's just what she said. Maybe it was loaded, but I want you to think about this. Who goes to the store, who has a suspended license and who is a convicted felon, to get whatever, and takes their firearm out of the glove box, loads it, and lays it on the seat? Bad idea to be driving around like that in town. Could cause you some problems. Think about it. But maybe that is what he did. And if it is, then the firearm was just all the more ready and accessible. But if he didn't, what steps did he have to go to get that gun out to use it? He had to open up the glove box. He had to remove the gun from the holster. If it was loaded, that's all he had to do, right? If it wasn't, he had to insert a magazine. If he inserted a magazine, he had to rack around. And then, of course, he had to pull the trigger. All acts that one would have, these are not acts you just do spontaneously and suddenly. They're acts upon which you reflect. I mean, it takes some thought. You're not a robot. But take those two out. He's still got to get the gun out of the glove box. And who hasn't driven a stick shift and drank a soda from Burger King or eaten a Subway? I mean, you know, it ain't easy and it ain't pretty, but it's not like it's impossible to do any other acts while you're driving a stick shift. But whatever. At the minimum, he had to do those things. What else mitigates against or proves that this wasn't a sudden and spontaneous act? He executed this plan with tactical precision. I want you to reflect back on what the witnesses told us. It was both Jerry and Albert. Now, he's running. He's in the lead. Keep running. Run, run, run. Run till you can't run no more. But he doesn't keep running. Right? And we know there's no contact. He's not pitted. He's not rammed. He's not touched at this point in time. Why does he elect, when he's in the lead, to slam on the brakes? Knowing Gary's not going to be able to stop in time. And Gary, as he would do normally, out of respect for his safety, takes evasive action, pulls around him, comes to a stop, and now he's in a really bad spot. He's at a significant tactical disadvantage. And so what happens? Does the defendant freak out in his car and start shooting holes in the windshield or through the roof, or otherwise act spasmodically or spontaneously without any thought? No. What, I think, does Albert say? Albert described it as almost mechanical, methodical, as he said walked over to the car, I think, a couple of times. And then I think Mr. Eisenhower said, well, I mean, was he walk? No, it was more a quick walk, or however he described it. But the point is, he's out, he's approaching Gary's car. Where does he fire the first shot? He doesn't fire it on the left side of the car. He doesn't fire it into the bumper. He fires it directly down the side of the car that Gary's getting out of. Tactically, a well-reasoned shot. Now, he didn't hit his target, but he's aiming for his target. And we know, here's Gary Morales, a sergeant with the St. Lucie County Sheriff's Office with how many ever years of experience, and as a trainer of people on self-defense or whatever it was in his training time, how to utilize firearms. And the man that is an expert can't get his own gun, 1, 2, 3, out of his holster. He's able to get a tactical advantage on a 2-decade senior law enforcement officer before he can even get his gun out of his holster. Now, these are not sudden and spontaneous. You can't just do that sleepwalking. That requires thought, right? That's clear evidence of premeditation. And again, they argue to you, well, it wasn't his plan. Because, you know, why would you do something like this with all these cops in it? He had no idea all those cops were in the area. You can't give him any credit for the fact that there happened to be cops, additional officers in the area. Makes no sense. Sudden and unexpected. And how about this? How's this for sudden and unexpected? How about you freak out, you fire off a shot, and then you run like hell. Jump over the fence, you get out of there. Go. Or don't shoot at all, probably be the best thing, leave your gun in the car and take off. But he decides he's going to shoot once. Okay? Well, then twice. Then 3 times. Then 4 times. Then 5 times. Then 6 times. 7 times. He shoots 7 times. He pulls the trigger 7 different times. And mind you, Albert tells you there's a delay in there. And you know that's true. And do you know why it's true? Because probably, hey, whatever, take it for what it's worth, but the last shot is while Gary lies dead, leaning over the console of his car, and there's that room in between, right? There's that room, and that shot goes straight through the computer into the passenger door. It makes perfect sense, because as Gary's trying to get out of the car, his body would have blocked the ability to fire that shot. But not satisfied with the damage he had done up to that point in time, he throws one in for good measure. You know, I can't crack open a person's mind and tell you what you're thinking, but I can point you to the facts. And then I think this probably would give you some insight into premeditation. How about where one shoots someone? Now, if your goal, first of all, if it's sudden and spontaneous, that means no thought. That means, I don't even know, it's like sleepwalking, if you will. It's just, you lost it, you snapped. Something like that. But you won't get a snap instruction either. Where does he shoot him? Well, here, this bullet I talked to you about a moment ago, right? So, this bullet doesn't hit. But where it's located is really important. Because what is happening is he's coming up this side with his gun. What's happening? First of all, Gary's working like heck to get out of that car. Remember Gary and Albert? He knows he's in a bad spot. He's been on the job long enough to know, I've got to get out. This car is my coffin. I have got to get out of this car. And he's trying to get out, presumably taking his seatbelt out or whatever it is he's doing, and he gets that leg out, he kicks that door open, and he's reaching his arm out. But who's got the tactical jump on him? And who's pressing his advantage? That guy, right there. And that first shot is a shot that reacts to Gary's movement. This is thinking. He's shooting towards Gary. Now he doesn't, presumably this shot does not hit Gary. Then there's a deflection. Whereas, and again, can't order the shots, but you take a look at the evidence and see if this doesn't make sense in light of what the witnesses said. Right here. Gary's arm is out of the car. Now, Mr. Glenn said something really interesting. Well, like Clarence Bennett. Clarence Bennett's a 9-year trade officer. If he wanted to hit my client, if my client was really out of the car moving and he wanted to hit my client, he would have hit him. Well, guess what? He was a moving target. That's a big difference. It's not easy to hit a moving target from 100, at least 139 feet, whatever that distance would be back to that wall, presumably. But he has a fairly stationary target. And the directionality of that bullet, this one, that entered Sergeant Morales' left shoulder, is, as you can see, the hole is back. The hole is back here, just under to the right of the chevron. In other words, coming from the back as his arm is out. And what is he doing? Is he pressing his tactical advantage? Sorry about that. Or does he stop with this shot? He continues to move, and this is what both Jerry and Albert told us, right? That he's continuing to move. And again, it's purposeful movement. It's the way Jerry describes it is intentional. And what? A shot that goes dead center, mass of the body. Now, is this the third? Is this the fourth? I don't know. But here's the thing. If you want to kill someone, you don't aim for their pinky or their foot or their leg. You aim for their chest. The biggest area there is. You want to give yourself the best shot. If you want to kill someone, that's where you aim. But he doesn't stop there. Because we have this shot. So now, as he's shooting, he's standing at Gary's door, right where Clarence Bennett saw him. He's raising his gun, shooting, moving towards his head. People who engage in sudden and spontaneous acts, whatever those are, don't go for the headshot. That screams premeditation. His intent from the moment Gary pulled behind him was to avoid being arrested. And then when that became up to a point where he didn't think it was going to happen, he acted. So, sudden and spontaneous. And now apparently, I guess, also, we have testimony from Sarvis that's also a lie. But what Sarvis tells you is when he sees the defendant, after, remember what he's done now, he's going out on US 1, he's come by, and there's Stubley, who knows, incidentally, which I think this tells you a lot. He knows, at that point in time, the man driving that red car just shot a law enforcement officer. And he has him in his sights and would be justified from top to bottom to have pulled that trigger and killed him in that car. But he did not. He did not out of concern for the safety of the citizens that were in that area. And so he exercised restraint. And so now here he is, having killed an officer, knowing that they got him in his sights, and he comes up to that corner, and I ask you, if it's sudden and it's spontaneous, and you've now apparently woken from your stupor enough to be able to lead multiple cops on a multiple city block chase, how can you be smiling and laughing? How can you be smiling and laughing? Now, let's be fair. That's after the fact. That doesn't prove premeditation, right? But it does tend to disprove sudden and spontaneous, because if it was sudden and spontaneous, what he would be coming to the realization of is, oh my God, I killed someone. But,
Yes, sir.
so again, if it's a sudden and spontaneous event that causes him to take a human life, when it dawns on him, what he did, he shouldn't be smiling and laughing. He shouldn't be smiling and laughing. But he was. He was. So the defense mentioned this to you, these lesser included offenses. And I'm going to talk to you about them very briefly, and I'm getting ready to sit down. But what the judge will tell you the law is the law says if you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. Now remember, another instruction he's going to give you, and this is the what-if question I talked to you about in jury selection. As you go back there to consider the evidence in this case, you shouldn't be considering what happens if we convict. This is about a search for the truth. Wherever that may take us in the end, your verdict should speak the truth. So don't go back there thinking what if, because the judge will instruct you that's not appropriate at this time. And more importantly, you certainly shouldn't go back there because it would be a violation of your oath and convict of a lesser to avoid having to go any further in this process. That's not how it works. And I'm not lecturing, I'm just telling you what the law is. You're going to get a verdict form. It'll look like this. It'll have each count on it. The first count is count 1, and then of course aggravated assault and all those. I couldn't get them all on one page. But it's just basically we the jury find the defendant as to count 1, and you can select only one. There is only one verdict in this case, and that's guilty of first-degree premeditated murder of a law enforcement officer, because that's the verdict supported by all of the evidence. You're then asked, once you found the defendant guilty, to answer these questions down here. If he discharged a firearm, which resulted in the death of Gary Morales, if he discharged, and if he actually possessed a firearm. And you need to check all of those that apply. Ladies and gentlemen, your verdict must be based on the evidence and on the law contained in these instructions. It can't be something you imagine. It can't be some theory that has no evidence, record support, that didn't come out in this courtroom. It can't be, I don't know what the truth is, but I'm going to try to fill in the blanks. Your verdict must be based on the evidence. Because the point of this whole process is, and it goes back to where we all started, is you don't know what the truth is until it's been subject to the crucible of cross-examination and your ability to examine witnesses' demeanor and credibility. That's why we're here. Otherwise, we don't need jurors, right? You must base your verdict in this based on the evidence of the law. They say it's sudden. I tell you, no, it's not. This is cold. This is calculated. I start off where I ended, or I end where I started off, and that's to tell you that on February 28th, he didn't have a license. And he decided to get in a car. Nobody made him. And in that car, he kept a gun that was his. Nobody made him carry that gun. And he was a convicted felon. And therefore, he was subject to the law for carrying that firearm. And he was stopped by a cop who was just doing his job. And there's no evidence or anything to indicate the contrary. And ultimately, after a short pursuit, having at least a minute and 27 seconds to think about it, he exited his car. Nobody made him do it. He didn't have to do it. He didn't have to take a human life. And he fired 7 times at a law enforcement officer, ultimately striking him in the center of his head and side and killing him. This is nobody's fault but his. Ladies and gentlemen, again, on behalf of myself, Daryl, and your state attorney, Bruce Colton, and the people of this state, I thank you for your time. I thank you for your attention. I ask you to pay very close attention to the judge's instructions on the law. And at the end, I want this journey for the truth to end where it should, and that is in justice. And justice can only be had if you follow the law and the facts. And when you do that, you be unanimous. He murdered Gary Morales in cold blood. Thank you.
Anybody that wants to leave prior to me instructing the jury, now's the time. Once I start, I'll politely ask that nobody get up so as not to distract me or the jury. wish to leave, please do so now. The jury, just bear with us a minute. The rest of you all, of course, welcome to stay, but please wait till I'm finished so the jury isn't distracted, nor am I, please. Thank you. Members of the jury, I'm required to read these instructions to you. When I'm done reading them to you, a written copy or several written copies will be provided to you all when you retire to deliberate. So you don't need to memorize all this or write it down. Several copies will be provided to you all when you retire to deliberate, along with the exhibits that have been admitted to evidence. Members of the jury, I thank you for your attention during this trial. If you'll please pay attention to the instructions I'm about to give you. Eriese Tisdale, the defendant in this case, has been accused of the crimes of first-degree murder of a law enforcement officer with a firearm, aggravated assault on a law enforcement officer with a firearm, possession of firearm by a convicted felon, and fleeing and eluding police officer with lights and siren. In this case, Mr. Tisdale is accused of first-degree murder of a law enforcement officer with a firearm. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Gary Morales was killed by Eriese Tisdale, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. First, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or second, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or third, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you in the circumstances that must be proved before Eriese Tisdale may be found guilty of first-degree murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. First, Gary Morales is dead. Second, the death was caused by the criminal act of Eriese Tisdale. Third, there was a premeditated killing of Gary Morales. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. If you find the defendant guilty of first-degree murder, you must then determine whether the state has further proven beyond a reasonable doubt that Gary Morales was a law enforcement officer engaged in the lawful performance of a legal duty and that Eriese Tisdale knew that Gary Morales was a law enforcement officer. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof, who is vested with the authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. Employing agency means any agency or unit of government or any municipality or the state or any political subdivision thereof or any agent thereof which has constitutional or statutory authority to employ or appoint persons as officers. The term also includes any private entity which is contracted with the state or county for the operation and maintenance of a non-juvenile detention facility. The court now instructs you that every St. Lucie County Sheriff's Deputy is an officer within the meaning of this law. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. First, that Gary Morales is dead. Second, the death was caused by the criminal act of Eriese Tisdale. Third, there was an unlawful killing of Gary Morales by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find the defendant guilty of second-degree murder, you must then determine whether the state has further proven beyond a reasonable doubt that Gary Morales was a law enforcement officer engaged in the lawful performance of a legal duty, and that Eriese Tisdale knew that Gary Morales was a law enforcement officer. Law enforcement officer means any person who is elected, appointed, or employed full-time by any municipality or the state or any political subdivision thereof, who is vested with the authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of the penal, criminal, traffic, or highway laws of the state. This definition includes all certified supervisory and command personnel whose duties include, in whole or in part, the supervision, training, guidance, and management responsibilities of full-time law enforcement officers, part-time law enforcement officers, or auxiliary law enforcement officers, but does not include support personnel employed by the employing agency. Employing agency means any agency or unit of government or any municipality or the state or any political subdivision thereof or any agent thereof which has constitutional or statutory authority to employ or appoint persons as officers. The term also includes any private entity which is contracted with the state or county for the operation and maintenance of a non-juvenile detention facility. The court now instructs you that every St. Lucie County Sheriff's Deputy is an officer within the meaning of this law. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. First, Gary Morales is dead. Second, Eriese Tisdale intentionally committed an act or acts that caused the death of Gary Morales. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide. Each of us has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. First, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent. Or second, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or third, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. If you find the defendant guilty of manslaughter, you must then determine whether the state has further proved beyond a reasonable doubt that at the time of the manslaughter, Gary Morales was a law enforcement officer engaged in the lawful performance of a legal duty, and that Eriese Tisdale knew that Gary Morales was a law enforcement officer. The court now instructs you that every St. Lucie County Sheriff's deputy is an officer within the meaning of this law. To prove the crime of aggravated assault on a law enforcement officer, the state must prove the following 7 elements beyond a reasonable doubt. The first 3 elements define assault. First, that Eriese Tisdale intentionally and unlawfully threatened, either by word or act, to do violence to Clarence Bennett. Second, at the time, Eriese Tisdale appeared to have the ability to carry out the threat. Third, the act of Eriese Tisdale created in the mind of Clarence Bennett a well-founded fear that violence was about to take place. Fourth, the assault was made with a deadly weapon. Fifth, Clarence Bennett was at the time a law enforcement officer. Sixth, Eriese Tisdale knew Clarence Bennett was a law enforcement officer. And 7, at the time of the assault, Clarence Bennett was engaged in the lawful performance of his duties. The court now instructs you that a St. Lucie County Sheriff's deputy is a law enforcement officer. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may be found to have been in fear. An actual fear on the part of the actual victim need not be shown. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. It is not necessary for the state to prove the defendant had an intent to kill. To prove the crime of possession of a firearm by a convicted felon, the state must prove the following 2 elements beyond a reasonable doubt. First, Eriese Tisdale had been convicted of a felony. Second, after the conviction, Eriese Tisdale knowingly owned or had in his care, custody, possession, or control a firearm. Convicted means that a judgment has been entered in a criminal proceeding by a court pronouncing the accused guilty. A firearm means any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. Care and custody mean immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. To possess means to have personal charge of or exercise the right of ownership, management, or control over an object. Possession may be actual or constructive. Actual possession means the object is in the hand of or on the person, or the object is in a container in the hand of or on the person, or the object is so close as to be within ready reach and is under the control of the person. Mere proximity to an object is not sufficient to establish control over that object when it is not in a place over which the person has control. Constructive possession means the object is in a place over which Eriese Tisdale has control or in which Eriese Tisdale has concealed it. If an object is in a place over which Eriese Tisdale does not have control, the state establishes constructive possession if it proves that Eriese Tisdale has knowledge that the object was within Eriese Tisdale's presence and has control over the object. Possession may be joint, that is, two or more persons may jointly possess an object, exercising control over it. In that case, each of those persons is considered to be in possession of that object. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following three elements beyond a reasonable doubt. First, Eriese Tisdale was operating a vehicle upon a street or highway in Florida. Second, Eriese Tisdale, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. And third, the law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. Operator means any person who is in actual physical control of a motor vehicle upon the highway. Street or highway means the entire width between boundary lines of every way or place of whatever nature, when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, excepting devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder of a law enforcement are second-degree murder and manslaughter that have been previously described. The lesser crime indicated in the definition of aggravated assault on a law enforcement officer are aggravated assault. I'll now define that for you. To prove the crime of aggravated assault, the state must prove the following four elements beyond a reasonable doubt. The first three elements define assault. First, Eriese Tisdale intentionally and unlawfully threatened either by word or act to do violence to Clarence Bennett. Second, at the time, Eriese Tisdale appeared to have the ability to carry out the threat. Third, the act of Eriese Tisdale created in the mind of Clarence Bennett a well-founded fear that violence was about to take place. Fourth, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may be found to have been in fear. An actual fear on the part of the actual victim need not be shown. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. It is not necessary for the state to prove the defendant had an intent to kill. Also, lesser is assault on a law enforcement officer. I'll now define that for you. To prove the crime of assault on a law enforcement officer, the state must prove the following six elements beyond a reasonable doubt. First, that Eriese Tisdale intentionally and unlawfully threatened either by word or act to do violence to Clarence Bennett. Second, at the time, Eriese Tisdale appeared to have the ability to carry out the threat. Third, the act of Eriese Tisdale created in the mind of Clarence Bennett a well-founded fear that violence was about to take place. Fourth, Clarence Bennett was at the time a law enforcement officer. Fifth, Eriese Tisdale knew Clarence Bennett was a law enforcement officer. And sixth, at the time of the assault, Clarence Bennett was engaged in the lawful performance of his duties. The court now instructs you that a St. Lucie County Sheriff's Deputy is a law enforcement officer. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may be found to have been in fear. An actual fear on the part of the actual victim need not be shown. Also, a lesser is improper exhibition of a firearm. I will now define that for you. To prove the crime of improper exhibition of a firearm, the state must prove the following three elements beyond a reasonable doubt. First, that Eriese Tisdale had or carried a firearm. Second, Eriese Tisdale exhibited the firearm in a rude, careless, angry, or threatening manner. And third, he did so in the presence of one or more persons. If you find the defendant exhibited the firearm in necessary self-defense, you must find him not guilty. A firearm means any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. Also, lesser is assault. I'll now define that for you. To prove the crime of assault, the state must prove the following three elements beyond a reasonable doubt. First, that Eriese Tisdale intentionally and unlawfully threatened either by word or act to do violence to Clarence Bennett. Second, at the time, Eriese Tisdale appeared to have the ability to carry out the threat. And third, the act of Eriese Tisdale created in the mind of Clarence Bennett a well-founded fear that violence was about to take place. The lesser crime indicated in the definition of fleeing and eluding with lights and siren is fleeing to elude a law enforcement officer. I'll now define that for you. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following three elements beyond a reasonable doubt. First, that Eriese Tisdale was operating a vehicle upon a street or highway in Florida. Second, a duly authorized law enforcement officer ordered the defendant to stop or remain stopped. Third, Eriese Tisdale, knowing he had been ordered to stop by a duly authorized law enforcement officer, willfully refused or failed to stop the vehicle in compliance with the order, or, having stopped the vehicle, willfully fled in a vehicle in an attempt to elude the officer. Operator means any person who is in actual physical control of a motor vehicle upon the highway. Street or highway means the entire width between boundary lines of every way or place of whatever nature, when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except in devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. If you find that Eriese Tisdale committed first-degree murder of a law enforcement officer, or aggravated assault of a law enforcement officer, or possession of firearm by a convicted felon, or any lesser included offense, and you also find beyond a reasonable doubt that during the commission of the crimes he actually possessed a firearm, or that he discharged a firearm, and in doing so caused the death of Gary Morales, you should make those findings on the verdict form. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive or the frame or receiver of any such weapon. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it's offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to be made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether when the defendant made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that will apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits in evidence, and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's the judge's job to determine a proper sentence if the defendant is found guilty in counts 2, 3, or 4. Nor should you consider the potential punishment as to count 1 at this stage of the proceedings. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, necessary form of verdict has been prepared for you. I'll show it to you. I know y'all can't read it way over there where you are, but I'll show it to you and explain it to you. In the upper portion, you'll see where it says State of Florida versus Eriese Tisdale, defendant, as the case number. That's known as the caption. Underneath it, you will find language that says verdict. We, the jury, find the defendant, Eriese Tisdale, as to count one, selecting only one of these pleas, guilty of first-degree murder of a law enforcement officer as charged in the indictment, or guilty of second-degree murder of a law enforcement officer, a lesser-included offense, or guilty of manslaughter of a law enforcement officer, a lesser-included offense, or not guilty. Underneath that, you will find language that says, if you find the defendant guilty as charged, or of any lesser-included crime, you must answer the following question. We, the jury, further find beyond a reasonable doubt that during the commission of the crime, the defendant, Eriese Tisdale, select all these that apply, discharged a firearm, and as a result of the discharge, death was inflicted upon Gary Morales, or discharged a firearm, or actually possessed a firearm. On the second page, that's to count two, select only one again, please. Guilty of aggravated assault on a law enforcement officer as charged in the indictment, or guilty of aggravated assault, a lesser-included offense, or guilty of assault on a law enforcement officer, a lesser-included offense, or guilty of improper exhibition of a firearm, a lesser-included offense, or guilty of assault, a lesser-included offense, or not guilty. Further language you will find under that, it reads, if you find the defendant guilty as charged of any lesser-included crime, you must answer the following question. We, the jury, further find beyond a reasonable doubt that during the commission of the crime, the defendant, Eriese Tisdale, and select all that apply, actually possessed a firearm. As to count three, again select only one, guilty of possession of a firearm by a convicted felon as charged in the indictment, or not guilty. Underneath you'll find language that says, if you find the defendant guilty as charged of any lesser, guilty as charged, or of any lesser included crime, you must answer the following question. We, the jury, further find beyond a reasonable doubt that during the commission of the crime, the defendant, Eriese Tisdale, select all that apply, actually possessed a firearm. Finally, at the count four on the last page, again, select only one. Guilty of fleeing and eluding lights and siren as charged in the indictment, or guilty of fleeing and eluding a lesser-included offense, or not guilty. So say we all, and there's a place for the date and signature of your foreperson underneath. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Just a few moments, you'll be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with one of the officers as you exit the courtroom, where they will be guarded by one of the deputies while you retire to deliberate. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any of the violations of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, in just a moment, I'll have you all step into the jury room to begin your deliberations. Written copies of these instructions I just read will be brought back to you all, along with the verdict form and an exhibit that was admitted into evidence. As I've advised you, if you have a question about anything, if you'll please put it in writing, just knock on the door. One of the officers will be out in the hallway. They'll bring it to my attention. I'll get an answer into you just as quickly as I can. Likewise, if you all have arrived at a verdict, if you'll make sure whoever your foreperson is that he or she sign and date the verdict form, just knock on the door. One of the officers will be out in the hallway. They'll bring it to my attention and we'll reassemble as quickly as we can to receive your verdict. If any of y'all want to step outside to smoke, Mr. Kirby, or anybody else that wants to start smoking that hadn't, just knock on the door. One of the officers will take you downstairs to smoke if you wish. If any of y'all want to take a break just to get out of the jury room there, that's fine. If you'll just knock on the door, one of the officers will take you downstairs or outside if you want to take a break. As I've advised y'all, please do not deliberate or discuss this verdict unless all 12 of y'all are in the room at the same time, and please do not leave the jury room unless you're accompanied by one of the officers. Now, Mr. Bowden, Ms. St. Lot, and Ms. Garcia, if y'all can hang on just a minute or two for me. I'm going to excuse the other folks, but I'll talk to y'all in just a minute, okay? Okay, thank you all very much. Everybody but Mr. Bowden, Ms. St. Lot, Ms. Garcia can step into the jury room, begin your deliberations. Your lunch should be in there for you.
You may be seated.
Okay, y'all can just hang on just a minute or two. Let me have our approach. three alternates, I'm going to excuse y'all for now. If it becomes necessary, we may need you to return for the penalty phase proceeding if that's necessary. It may not be necessary, but it may be. So I'm going to excuse y'all for now. If y'all wouldn't mind giving a number where you can be reached, a cell phone or a house phone number to one of the officers. It won't be disclosed to anyone else. I'll just keep it in our custody here, where we can call you and let you know what time we need you to return, if at all. Yes, ma'am. Ms. Garcia.
I'm supposed to travel to another state for work on October 8th, Thursday, and I'm not to do so, or do you not want me to do
Okay, I'll let you know. Okay, but if you'll just, I'm working that out right now. But if y'all will just leave a number where we can reach you, I'll have either the clerk or one of the deputies call you and let you know when we need you back, if at all. Okay. Now, I do want to, before I let you go, emphasize to you, while you're potentially could be on the jury in this case, do not discuss this case with anyone or allow anyone to discuss it in your presence. Do not fix any opinions as to anything else until you're discharged formally, and I'll let you know when that happens also. Please, while this case is still pending, do not listen to any media accounts or read any media accounts until I discharge you from service on the jury, and please do not visit any of the places described in the evidence until I formally discharge you from the jury. Okay? Okay. Now, y'all are going to be free to go. You can leave your notepads there on their chair there for you. You're free to go, but if you'll just leave a number where I can have one of them reach it, and when and if we do need you, I'll direct you when to come back. Okay? Y'all are free to go now. I want to thank you. If I don't see you, I want to thank you for your service. I know it's been a long, however long it's been a while, but I appreciate your service, and so an alternate. We may see you again, but we may not. But please abide by those requests until I formally have you discharged. Okay? Thank you all very much. You're free to step down now. And they'll walk you downstairs. Just watch your step. Don't anybody approaching these alternate jurors. Nobody approach these people. Nobody approach these people. Nobody approach these people. Okay, we'll discuss this scheduling thing in a few minutes. Let's just go off the record. Y'all want to look at all the exhibits that are going back? Or?
Yes, sir.
Okay, if y'all look at that before it goes back. If there's any objections, let me know when I come back in. Thank you very much. We'll be in recess.